Hey everyone, and welcome to today's webinar. We're going to be talking today about how to tell whether someone is by law an independent contractor or whether they're an employee. So you don't need to know anything about the law about this in order to watch this webinar. We're going to do kind of the basics. But basically, if you hire people to do work for you or your business and you pay them as a contractor and not as an employee, or on the flip side, if you do work for other people or other businesses and you aren't an employee, then this webinar is for you. So also, if you're just curious and aren't doing that yet, but you want to figure out how to tell the difference between a contractor and an employee, this is what we're going to talk about today. So generally speaking, it's good for anyone who's on either side of that equation, but industries that we see a lot where this comes up are industries like the health and wellness industry. So acupuncturists, personal trainers, massage therapists, everybody like that. The beauty industry, hair salons, makeup artists, estheticians, everything like that. Creative industries, photographers, coders, and writers and artists, and all manner of freelancers. Really, this is a good one for, including also film and music. So if you think that applies to you, any of it, that's what we're going to be talking about today. So stick around, I will share my slides as well. And let's get going. So, all right. This is what we're going to be covering today. So generally, we'll go through this. We're going to do some foundations first, just to make sure you understand the basics before we go into the specific laws. We're going to talk next about the consequences of not abiding by what we're going to be talking about today, which can be significant. We're going to talk about the old test that used to apply and still applies sometimes, called the Barrello test. And then we're going to talk about the new test that came out over the last couple of years. The law that turned it into law was called AB5. It's been updated with a law called AB2257, but generally the law is often referred to as the ABC test. And then we're going to talk about all of the exemptions to AB5 that were included at AB5. So that's actually the most complex part, unfortunately. So who am I? I am Galia Aharoni Schmidt. I am a lawyer and a partner at my law firm, Aharoni Business Law. We are based in Oakland, California, but we have clients all over the state of California, and occasionally in other states and throughout the world if we're talking about California-based issues. So business, employment, IP, anything that comes up kind of as general counsel for your business. So we have been talking about independent contractor classification issues a lot since this law started changing a couple of years ago. And I wanted to do an update video on our really popular original video about AB5 when it first came out, because there's been an update. So that's what this one is. For context, I'm a California lawyer. This is the California law. I am assuming that we're talking about California workers as well. And it's possible that some of these rules might still apply if the workers are out of state. But generally, we're talking about workers in California doing business in California. Obligatory disclaimer, this is not legal advice. I want this to be for informational use to you, to give you the basics. So if you have further questions or you want to figure out how to apply this to you or your business, please contact my firm or another law firm to get more specific advice, okay? Unfortunately, we won't have time for questions today because we've got a ton of stuff to go over, but feel free to send them over, and we will do our best to follow up with you quickly and get any questions answered. Also, this will be recorded and it will be available online as well later. So feel free to like and subscribe to any of our social media. We're on YouTube as well. You can sign up for a newsletter through our website. Those are all places where you'll get updates on all the videos and articles and webinars that we do. So for further information, follow us. Okay, so let's dig in. Number one, why are we even talking about this? Why do you care? So it's important to talk about this because, we are in kind of a new economy, not just because coronavirus, but even before that, we were in this kind of more freelance economy that is pretty new, and more people than ever are freelancers and contractors and working for themselves. And these issues are really important to know how to tell if you're a contractor or you're an employee. And on top of that, The law has significantly changed over the last couple of years and continues to change. So before we get into the laws themselves, combo number one, what is an employee? What's a contractor? What's the difference? So generally speaking, someone who's an employee, the employer, I'll just refer to that as the business, has a lot of control over the work that the employee is doing. So that is, you can tell them when to show up and what to wear and what, to call themselves as their title and how to do the work. And you're in charge of the training and just, you can control basically every aspect of their job. But the burden that comes along with that privilege is if someone's an employee, there's a ton of laws that you now have to abide by. So there's just federal law, state law, county law, city law, and all of these things are things that you have to adhere to. Otherwise, you can get sued, usually by your employee. So these are things I'm talking about, like minimum wage and overtime, lunch and rest breaks, unemployment insurance, workers' comp insurance. Those are all the things that make it, you have a lot more control over the person, but you have a lot more responsibility and a lot more things you can get sued for generally. The flip side of this is an independent contractor. So it's the opposite. The company's control over the work that the contractor is doing is very low. You're really supposed to not have control over anything that you don't have to absolutely have control over to get the job done. So you're not supposed to tell them, if possible under the circumstances, when to show up, how to do the job, what tools to use, and we'll get into all those things later, but you really are not supposed to have a lot of control over the work itself. Just the only control you really have is over what outcome you're trying to get from them. Flip side of this though is none of those employment laws apply to you. There are some that still do apply. You can't, harass them or assault them or things like that, of course. But generally, you don't have to worry about things like breaks and workers' comp and things like that. So it's a lot cheaper and a lot less likely to be sued for those particular things, but you have less control. So a lot of the times employers prefer to work with contractors instead of employees because, like I said, they're cheaper and there are less rules you have to follow, less laws you have to follow. And why would a contractor want to be a contractor? Freedom, more flexibility. You have more control over how much money you can make probably, and you have more control over your schedule and the way that the work is done and who you work with. So there are a lot of people who want to be contractors, and also contractors tend to be able to charge more by the hour than an employee would, because the employer is not responsible for things like workers' comp and some of those extra taxes. So what is the history of these rules? It's not the most interesting part, but it is important actually. So in the 80s, there was a case that came out called Barrello. This was the case that basically created the old test. So it's usually referred to as the Barrello test. And we're going to talk about that a lot. After 1989, that was the test that they used for most things, not all things. But then in 2018, another case came through the courts called the Dynamics case, and it dramatically revised the Barrello test and replaced it. And it caused a lot of commotion and a lot of confusion. And because of that confusion, the state legislature came out with Assembly Bill 5 in 2019, but it started applying in January 1st, 2020, that turned that rule from the Dynamics case into a clear law, and they clarified what situations it applies to and other clarifications in there. So this is usually referred to as the ABC test. The ABC test from AB5 was still very confusing and frankly I think not well drafted. So they came out with an update in the end of 2020 called Assembly Bill 2257. So it kind of replaces AB5 and updates it, but the bones of it are the same. So really the purpose of it was just to clarify it, but they added some new exemptions and they added some clarification on some of the things that were confusing. In my opinion, AB 2257, it did clarify some things, but it also just made it even more complex and confusing in a lot of ways. So that's why I wanted to do this update video. We have a pretty popular video on our YouTube channel that goes over the original AB5 in detail, and some things have changed since then. So that's why I wanted to get everyone up to date. As far as future slides, I have put a little red asterisk next to everything that changed between AB5 and AB2257. So if you're familiar with AB5 already and just want to know what's different, pay attention to those ones. If it doesn't have an asterisk, then it's the same as before. All right. Also, one thing to note is we're still waiting on federal guidelines too. The feds have not, so far as the date of this recording, given any clarification on what they think the rules should be. So this, again, California is more strict than most other states, and also more strict than what the federal rules are usually for this. So last thing to keep in mind before we go ahead with the tests. All of the tests we're going to be talking about today have a presumption of employment. So that means if we're looking at the relationship between a business and a worker, then the government is going to assume the person is an employee unless you can prove that they're not. So that means that the burden is on you. It's a lot harder to prove that they're not an employee than otherwise. So remember that this is all hard. This is all a hard test, even if we're using the easier test that we're going to be talking about. A quick definition of misclassification, that just means we have been treating someone as a contractor, but by law, they are an employee. So they have been misclassified as a contractor when really they were an employee the whole time. So if I use that phrase, that's what that means. And then to clarify again, if AB5, excuse me, doesn't apply, it doesn't mean that there's no test that applies. It means that the old rule, Barrello, applies. So I will drill that into your head a lot throughout this hour, but it's important to remember because a lot of people think if an exception applies, then it's a free-for-all and the person's definitely a contractor, and that's not how it works. So one question I get here a lot is, why does the government care? Why does the government want as many people as possible to be employees? So there's two answers to that. One is optimistic and one is more cynical. The optimistic version is, I think the government saw that because of this kind of freelance economy, some companies were taking advantage of contractor freelance workers and wanted to make sure that all the workers were protected by law as much as possible, and getting things like minimum wage and breaks and overtime and workers' comp. So part of it is a little bit of white knight thing where they're trying to protect contractors from getting taken advantage of, which is positive. But I also think, this is the cynical answer, the government makes more money off of employment taxes than they do on self-employment taxes for freelancers. And they also just have more control over the relationship if it's an employee relationship instead of a contractor relationship. So I do think that there's a little bit of fear in the government because this model of work is new and unfamiliar and therefore scary. And I think the government wants to keep control as much as possible and wants to make as much money as possible. So that's my cynical answer. It's just my theory. I'm sure some politicians would disagree with me, but I think that's where it's coming from. Okay, so before I even get into the tests, I want to talk about the consequences because I want you to know that this is actually very, very serious. Everything we're going to be talking about is super complicated. It's a huge pain in the butt to try to comply with. It's easy to want to avoid going through all of this and just say, you know what, I'm not going to think about this. I'm just going to do my thing and it'll be fine. So I want you to know the basics of what could go wrong if you don't follow these rules, because I do want you to know that this is very serious and frankly can close your business if you don't do it right. So if you apply one of these tests and the relationship doesn't pass these tests, so we're talking about Barrello or AB5, that means that they've been misclassified and they are legally an employee. That means that any minimum wage they would have been owed, any sick leave, overtime, expenses, breaks, unemployment insurance, workers' comp insurance, leave, disability benefits, any benefits and things that would have been owed by law had they been an employee the whole time is now due to them. And that can be expensive and difficult. On top of that, there are more consequences too. So on top of everything that owe them for back pay and back benefits and back taxes, you can be slapped with fines. You can be slapped with big penalties. And the penalties are even bigger if they find that there is willful misclassification, and they almost always find that it's willful, even if you really didn't know. They almost always find it's willful. And civil penalties as well, on top of all of the back pay and penalties and everything. The new law also added the possibility of injunction, of making you stop doing the thing that you're being sued for. So these can add up dramatically. And I have seen successful small businesses have to close because of getting an audit and getting slapped with $80,000 or more of penalty. So it all depends on how much you have been, how long you've been working with them, how much you paid them, all of that. Sometimes it's negligible, sometimes it's huge. I don't want your business to have to close because of this. And I know I wouldn't be able to come up with 80 grand if I got audited and had that slapped on me. So who can come after you for this if you break this rule, whether accidentally or on purpose? Number one, you can just get sued individually by the worker. So it can be an individual lawsuit or a class action lawsuit, but that's going to be for things that they would have been owed had they been an employee the whole time. So minimum wage, missed breaks, reimbursements, things like that. So you can't just get sued directly. I've also seen this happen even when the person wanted to be a contractor, but got hurt and needed workers' comp coverage. So then they had to sue and ask for workers' comp coverage, things like that. It can be a big problem. Even if the employee doesn't have a problem being a contractor and doesn't tattle on you at all, agencies can still come after you individually. So there's a whole bunch of different agencies that can individually come after you, either by a tip from a worker or totally on their own. So the most common ones I see are the EDD. So that's the Employment Development Department. That's the ones who are doing unemployment insurance and disability. The next one I see most often is the labor board, the DLSE. They're going to care more about wage and hour infractions and also workers' comp insurance. But the FTB, the workers' comp board, the contractors board can all come after you. So can the IRS and things like that as well. So again, they're empowered to come after you just because they want to. And I've seen them target industries and I've seen them target geographical areas. So even if, again, nobody's tattling on you, you still can get in trouble for this. Finally, this AB5 also enabled some cities and some local attorneys to come after you, again, without a direct complaint. So attorneys general, city attorneys, local prosecutors in certain situations can sue you directly as well, again, whether or not someone has tattled on you. So I'm not worried about that one for you small businesses, but I just wanted to let you know that all of these things can happen separately or at the same time, and whether or not someone tattled on you or not. And so it can be pretty bad. Another thing is these agencies can talk to each other, and they often do. So let's say someone who is a contractor applies for unemployment wrongly, and you contact the EDD and you say, sorry, they were a contractor, not an employee. I don't owe them any unemployment insurance. The EDD says, okay, well, in that case, we're going to audit your entire business and all the contractors you've worked with for the past 3 years. So that sucks. And then you try to cooperate with them, but argue that everyone has been contractors. And then suddenly you get a letter in the mail from the labor board saying they're auditing you too. This is totally common and it sucks. So again, I don't want to be super scary here, but I've seen this go really bad for a lot of small businesses, and I want you to take it really seriously. Okay, we talked about those. There's also just some hidden implications that people don't think about when we're talking about the difference between whether the work someone did for you was as a contractor or as an employee. So the rules are different in all of these situations based on whether the person was a contractor or an employee. So IP ownership is going to be different. If someone created a website for you and they were a contractor versus an employee, who owns that website is different based on the relationship you had. Same thing with workers' comp. If you didn't cover someone and you thought they were a contractor and they get hurt and you get audited and or in the lawsuit find out that they had been an employee the whole time, it matters whether you cover or not. Same thing with unemployment insurance. And also just, again, potential liability if the person was driving on a job for you and they get in a car accident. Whether you're responsible or not has a lot to do with whether they were legally a contractor at the time or an employee at the time. So again, it's not just the audit of this relationship either. There's all these kind of waterfall effects as well. Finally, again, like I said, AB5 is a California law. So it doesn't apply to federal stuff like federal taxes. The IRS has its own test for this. And the Affordable Care Act, if you're trying to figure out if you have to abide by the Affordable Care Act based on whether you have 50 workers or 50 employees or not, this doesn't apply. There's its own test for that. And again, remember these tests too, all the tests we're talking about today are still really pro-employment. Okay. All that boring stuff aside, let's get into the tests themselves. So there's a couple different tests we're talking about. And this is kind of the flow of how this works. So number one, if you came to me and you wanted to figure out whether a relationship was a contractor or an employee, number one, we're just going to get some basic information about the relationship. What does your business do? What does their business do? What is the relationship like between the two of you? And then from there, we are going to kind of go backwards and figure out whether an exemption applies. So we're going to spend a lot of time today talking about the long list of exemptions to AB5. So if an AB5 exemption applies, we're going to follow that line up and we're going to apply the Barrello test. If an exemption doesn't apply, then we're going to follow the line down and use the AB5 test to do our analysis to figure out whether we think this relationship is a contractor relationship or an employment relationship. Okay. After we do that analysis, we're going to have an opinion. I think this person's a contractor or I think this person's an employee. And based on what the relationship looks like then, we're going to give recommendations on, I think that they are a contractor, so that's great, but let's make sure we're abiding by the rule as much as possible. So, let's make sure we have a written contract or something. Or, this person's been treated as a contractor, but we really think they're an employee under the law. So let's talk about converting them to employees or what else we can do. Okay. So that said, let's talk about the old law, Barrello. So this is, again, is if an exemption does apply to AB5, we're using this test. So the whole gist of Barrello is, does the business have the right to control the manner and means of the work that the worker is doing? So there's 11 different things we're going to look at to try to figure out, this is more of a sniff test. Does this feel like a contractor relationship or does this feel like an employee relationship? So Barrello is an overall picture test, not, a single one of these factors, yes or no, is not going to automatically make the whole test an automatic yes or an automatic no. We're looking at all of them combined. Does it feel like a contractor or does it feel like an employee? So let's go through all of these together. So number one, can the company, do they have the ability to fire the worker at will without cause? So if they can fire them at any time with or without a good reason, it looks more like an employment relationship than a contractor relationship. And part of this it goes back to control. If you have the ability to fire someone at any time for any reason, then you have more implicit control over the work they're doing, because they're going to want to please you and do anything you ask because they don't want to get fired. So that is opposite kind of the contractor relationship, where there's a written contract and I can only fire that person if they do, if they break the law or very specific things. Then they have a lot more control than an employee to do the job as they want. Number two, is the worker engaged in a distinct occupation or business? So if the more different the work they're doing is from what you do, the more it's going to look like a contractor. So if my law firm has a physical office and I'm hiring a plumber, that's super different from what I do, obviously, and that's going to look more like a contractor. But if I'm contracting with a lawyer or a paralegal, that it has a lot more overlap. Okay, the kind of work and whether it's usually done with direction, or supervision. So again, we're kind of looking at the more specialized the work is, the less likely they're going to need supervision, and the more likely they're going to be a contractor. So again, even a plumber is going to have very specialized skills that I'm not going to know anything about. But also we're talking about, skilled professionals and things like that are going to be more likely to be a contractor because they can do the job without supervision. Number 4 is related. What is the skill required? The more skill required to do this job, the more likely they're going to be a contractor, again, because they're going to have more kind of inherent control over the work they're doing. Number 5, the opportunity for profit or loss. So this makes sense when you think about it. So if someone is an employee, they're probably just getting a salary, and no matter how much work they do or how little work they do or how good a job they do or how bad a job they do, they don't have a lot of control over how much money they're actually making. Even if they end up making the company way more money, they're probably, making about the same. If a contractor is doing work, say by the hour, and they're setting their own hours and they're deciding how much they want to work, and they're deciding what the systems are so they can make it more efficient if they want, they have all these levers to pull about how much money that they individually can make. And the more opportunities like that, the more levers they can pull to control their own profit or loss, the more it's going to look like a contractor instead of an employee. Number 6, we're looking at who provides the tools and the place that they work. And so again, we're looking at control of if a contractor gets to use their own tools and they get to decide where they're working, then they're going to have more control if they're being told where to go and what to do and how to use it, what tools to use, excuse me. They are going to look more like a contractor. Did I say that right? You know what I mean? So we want to make sure that the only tools that are being provided to the worker, if they're a contractor, by the business are things that absolutely can only be given to them by the business in order to do the job correctly. Okay, workers' financial investment. That's very similar to the one we talked about on the last slide about profit and loss, but it's more about has this worker put money and labor into the work? Have they bought their own tools? Have they, spent the time and money to build a business? Have they built a website? Just how much money have they put into doing this? And also related to the profit and loss thing, equipment and tools and expenses. How much control, how much are they putting into the expenses and being in control of how much profit and loss they're making? It's all related here. Okay, what's next? Length of time. So the longer the relationship lasts, the more it looks like an employee, whereas on the flip side, a contractor is going to be shorter in time and more likely to be kind of project-based instead of indefinite. Method of payment is next. So generally speaking, this is relative to the job, but generally, if someone's being paid by the hour and getting paid every 2 weeks, that looks more like an employee versus they're getting paid per job. That's going to look more like a contractor. Number 10, whether the work is part of the regular business. So again, that goes back to my plumber versus paralegal example. If the work that's being done is a part of the regular business of the company, it's gonna look like an employee. So if I'm having someone, again, do paralegal work or come in and do admin and answer my phones, those are things that need to be done in the course of the day of my law firm. But a plumber coming into the office to fix the sink is not gonna do that. And number 11, what do the parties believe? Do they believe this is an employment relationship or a contractor relationship? And to that end, it can be really helpful to have a written contract to kind of solidify the relationship and make it very, very clear that everyone believes this is a contractor relationship. So again, we're looking at all of these at the same time as a whole. You don't have to satisfy every single one of these, but the more of them together that look like a contractor, the more likely this is going to legally be a contractor test. So there is some flexibility involved in here because you don't have to hit every single one of them. But remember, this is still a super hard test. And there's still a presumption of employment that is really hard to overcome. So even if we're using this test, don't think it's just kind of, an easy ride, because this is the test we were using all the time until a couple of years ago, and it still was very, very hard to win once you were battling this. So that was the Barrello test. The new law comes from AB5. We'll call it the AB5 test or the ABC test. So again, remember, there's a presumption of employment here. And the difference here from Barrello is there's only 3 factors, but all 3 of them you have to pass all 3. And that makes it harder because there's no flexibility and very little flexibility involved. It's a very rigid test and it's hard to hit all 3 of these. So again, the reason why I think they wanted to tighten up this rule is because of this new freelancer economy and companies like Uber, who before this test had been made and before the updates, the propositions and things were passed about Uber in particular, the government was feeling like those companies just had made too big of a net and were taking advantage of people. So this really expands the test to apply in most situations where classification is an issue. So you need to know this if you're gonna be working with contractors. So let's just dig in to the 3 factors. So factor A, the company does not have the right to exercise control over or direction over the worker's services. So this hopefully sounds familiar if you were paying attention to the last 10 minutes or so, because basically this is the entire Barrello test wrapped up in 1 factor. So I do want to point out, this is very subtle, but it is the right to control the worker, not whether you are actually controlling the worker. So it's, the government or the agency, whoever's looking, they're going to look at whether you had the right to control them, even if you weren't actually controlling them. So again, what they want to see is control over the results only and not the method of doing the work. So again, I'm hiring my plumber to come into my office and fix my sink. I'm not telling them when to show up, what tools to use, how to actually do it. I'm only dictating the outcome. But if I hire an admin to help me with some office tasks, I'm going to have to tell them when to be in the office. I'm going to have to maybe have them on site. I'm going to have to tell them how to answer the phone. I'm going to have to tell them what work to do and when and how, and I'm going to have to train them. And all of those factors that we had talked about before, we're now looking at here. This has come up a lot. Some issues that we have worked on with people. One example was just actually pre-AB5. This is just the Barrello test. We had a client who did corporate team building, and They got audited, and the only control they had over the worker here was they had a listserv of actors, and they would tell them if a gig was happening, and an actor would reply and say, I want that gig. They would tell the actor where to be and what to say if a scavenger hunt team found them in that location. They, didn't have to take the job. They only worked a couple times a year if they wanted to, for a few hours at a time. And the EDD said that that was an employee. And so again, because they had control over when they showed up, what to say. And that was it. That was all they needed. And so that's how strict this control test is. Okay. Same thing when we're looking at studios like acupuncture studios or yoga studios that typically have their workers come in, the place will be owned by one owner, and then the teachers or the practitioners will come in and be contractors, but they'll be told by the company when to have their classes or when to have their appointments, and the company will be the one setting the client appointments up for them and taking the money and then passing it along to the practitioner. And that's all things that look like too much control. So again, I'm not going to go through all these because they're straight from the Barrello test, but we're looking at things like, can they be fired anytime? How are they paid? How long is the relationship? How skilled are they? How similar is the work to work that needs to be done? And again, for this particular factor, no single fact makes it an absolute yes or an absolute no. We're looking at the whole. But if enough factors look like an employee, then the entire ABC test fails and this person is an employee, okay? So factor A, control. Factor B, the worker's services are outside of the company's usual course of business operations. So this also sounds familiar. It's one of the factors from the Barrello test, but made its own separate factor that's now required. So this says that the contractor shouldn't be doing work that the business normally does within the operations of the business. So we've already talked about this, but generally, is the work related to the core business of the work? So this seems like it should be pretty straightforward, but once you start thinking about it, it's actually not as straightforward as you think. We're looking for kind of what are normal day-to-day operations like in this business? What are the key services you provide? So for example, if my law firm is hiring a lawyer as a contractor and they're doing legal work for my clients, that's going to be within these usual course of business operations. But if you, business, are hiring me to be your lawyer, and you aren't a law firm and you're doing something totally else, then that relationship is going to be outside the usual course of your business. So this rule really wants contractor relationships to be kind of these traditional contractor roles: plumbers, electricians, lawyers, accountants, all of that, and leaves a lot less room for the gray area. So the question you have to ask yourself here, which seems obvious but often isn't, is what are the services that you actually provide? And this was one of the main issues when Uber was fighting about this. So Uber would say, our business is software. We made a software platform that is connecting drivers with riders, and that's it. And the state was saying, no, you provide rides to people. If someone asks, if you ask someone on the street, what does Uber do? They say they provide you rides. And so, that was the key to the analysis for Uber, because if they are in the ride sharing business, then their drivers are within the usual course of their business. But if they're in the software platform business, then their drivers are not within the usual course of their business. So it can be a really big deal. Again, another example of clients that we've helped where this factor came up is a doula company that provided doulas and nannies to families, and their website says we're a doula company that provides doulas and nannies, but the doulas and nannies were classified at the time as contractors. So The options are, if you're a doula and nanny company, then these doulas and nannies need to be employees. But if you are a referral agency and your job is to provide vetting services and to connect doulas and nannies with families, but you're not actually providing the services, then that's different. And that can allow the workers to be contractors. So if that's the case, we probably need to do an entire overhaul of your website and the structure of your business to make sure that it's actually the truth, that you're a referral agency and not a doula company, right? So there is still plenty of room for gray area here. If an ad agency doesn't have a full-time copywriter on staff, and they outsource some copywriting every once in a while, is that within the usual course of business? I don't know. We also have worked with a custom cabinet company, and they had a wood finisher come in sometimes to do some wood finishing. Does that count? Is their job custom cabinetry, or does that also include wood finishing? Things like that have been coming up a lot. So you might need to have some time to sit down and ask yourself what your business actually does. The final factor here, factor C, the workers engaged in an independently established trade, occupation, or business. So basically this means the government wants the contractor to have their own business, and they want this business to exist independently of the relationship with you, the company. So, once this relationship ends, this person is still a professional, fill in the blank, and it doesn't matter whether they're working for you at the time or not. So again, we're going to look for things like, do they have other clients? Is it full-time or part-time? Is it ongoing or short-term? Do they have specialized training that gave them the ability to do this thing professionally? Do they have a website? So again, all those things are really wanting to stick to that kind of traditional contractor relationship, like your plumbers and your accountants. So this one still has a surprising amount of ambiguity baked into it that isn't always clear. So for example, if I hire someone on Fiverr to make a logo for me, does having a Fiverr, page mean that they have their own business that satisfies this rule? I don't know. Probably. It might depend on what else they're doing, or what the work is that they're doing for me. Also things like, there are plenty of consultants who work full time for one company at a time for long periods of time sometimes. So what if there's a consultant who's only working with you? Does that, again, it's going to look at a lot of the other factors too, but it's not super clear. And again, if I'm talking about my law firm as an example, let's say I'm working with a contractor paralegal. Is this paralegal working just for me and doing whatever I ask them to do? Or is it a professional freelance paralegal with multiple clients at the same time and a website? And I don't give them instructions on what I want this document to look like. They're just drafting it for me and I'm editing it. There's a big difference there. And I do think there'll be a lot of lawsuits here too. So again, some factors we're looking at: do they have a website? Do they have a separate office? Do they have their own insurance? Do they have more than one client? Do they have a business license? Do they have their own equipment? How are they being paid? So again, these factors within the factor C, no single fact makes factor C an automatic yes or an automatic no. But if enough factors look like an employee, then the entire ABC test fails and this person's going to be an employee. Okay, so to recap, you need all three of these. 1, no right to control the work. 2, the work they're doing is outside the usual course of business. And 3, the contractor has an independently established trade. Okay, so this is a really hard test and we don't want to have to go through this test if we don't have to, because Barrello itself is hard enough. So these are the tests. Let's talk about the exceptions to the test. So there are a lot of exemptions. I think the last count was over 100. One of the questions I get here is like, well, why these and not these other ones? The simple answer is the groups that had enough lobbying power to lobby successfully, they're the ones that had exemptions, and Nobody else does. So we might see more over time, either by law or through lawsuits. But for now, these are what they are. The exemptions are even more complex than the test itself, which sucks. And there's a lot of ambiguity and confusion built in here, which sucks, and a lot of complexity. So I'm going to go quickly over all of them, but I'm going to focus on the two that I think are going to come up the most. And we also will be doing a follow-up video just about exemptions and some articles too, in more detail. So if you want that, make sure to follow our social or sign up for our newsletter to stay up to date for those, but those will be out as well. It's just to get a little more detail. So again, even though I'm hitting you over the head with this, if one of these exemptions applies, it doesn't mean this person is automatically a contractor. It just means we're using the Barrello test, which is about control, remember? But it has a little more flexibility, even though there's still a presumption of employment, okay? So slide number one, these are the ones that have just explicit, straightforward exemptions for specific industries. So for example, if you are a doctor and you're licensed, you are automatically exempt from ABC test and you use Barrello. Same thing for dentists, lawyers, licensed architects and engineers, accountants, etc. Everyone on here. Most of these require licenses. So I think that's one reason they gave these exemptions, is because all of these industries are also governed by a licensing board. Salespeople are on here at the very end. So there are extra rules for salespeople. They can be contractors, but they can't be paid by the hour, and you have to have a written contract for them. So again, doesn't mean these people are contractors. It just means use the Barrello test instead. It also doesn't mean that people tangential to these people automatically apply. So I have a lot of calls from, licensed architects going, oh, I'm a licensed architect. I want to hire a drafter. Can they be a contractor? No, well, I mean, they could be theoretically, but this exemption does not apply. It only applies when the worker themselves is one of these things. Here's more: construction subcontractors, real estate licensees, businesses that obtain work through referral agencies. So this is its own test. So if you believe you qualify as a referral agency, like that Julo example I talked about a couple of minutes ago, there's its own test that I'm not going to go over, but you can contact us or watch for our follow-up videos and articles about this. But referral agency, generally, we're looking for companies like Rover and TaskRabbit, so that are just very clearly just an actual platform that they're, kind of maybe calling people, but they're not providing the actual services themselves. So if you think that might apply to you, then stay tuned and learn about this exemption, but it's pretty rare that small businesses at least fall into this exemption. So there's some random ones there too about commercial fishermen. Okay, these ones are brand new from AB 2257. These weren't in the original one. Most of these are about musicians and music adjacent things, at least these top few here. So single engagement events, that's things like a band playing at a bar or at a venue. And musicians and performers themselves have lists of exemptions here, and music creators. So again, we're looking for things like people who are creating, marketing, or distributing sound recordings or just musical compositions. So it includes songwriters, lyricists, and managers and producers and mixers and everything like that. One frustrating thing for musicians and for people in the film industry in general is that none of these apply to the film industry. So even if you're a musician, it doesn't apply for film or TV. So that's a bummer to a lot of people. Again, I'm not going in detail about these. So if you are a musician or a music creator or a filmmaker, that's a good opportunity to do a little more research, watch our follow-up stuff, and contact us or another expert in this, okay? And other random ones. licensed landscape architects, that one has come up with our clients a lot, but also insurance and weird ones like competition judges, and ones I didn't even put on here, like manufactured housing salesperson or professional foresters. So I doubt we have a lot of professional foresters watching this, but just in case. Okay, so here's where I get to the two exemptions that I think are actually going to apply to most people. The first one is called the professional services exemption. So the way that this works is there's kind of a two-step process here. Number one, is your profession listed on this slide? If so, move on. Choose your own adventure. Move on to section 2, step 2. Then we have this test we have to pass, and if we pass that test, then we can use Barrello instead of AB5. So here's some of the professional services that apply. So again, I'm not going to go through all of these, but this is marketing and HR and graphic design, artists, photographers, writers, estheticians, things like that. So again, there are definitions for most of these in the law. So if you aren't sure whether you qualify as an HR person under this law or a fine artist under this law, again, follow up with our other content or contact us. But generally, if you are on this list, then we do this. The worker has to have a separate business location, has to have a business license, which a lot of freelancers don't, have to have the ability to set their own rates and hours within reason. So of course, if we're doing something, if we're recording music, everyone has to be there at the same time, of course. So like you can say you need to be here, you need to be at the studio. Yeah, I can't generally, if I'm hiring outsourced HR, they're gonna decide how much they charge. They're gonna decide when they're working and where they're working. The government wants them to have other clients for the same type of work. And again, they use their own discretion in the performance. So some clarifications here. The separate business location can be someone's house. It doesn't have to be this like formal office, and and they can choose to perform the work on site if it makes sense to do so. But there has to be some place other than the location of where the work is going to, where the business is, the hiring business, that the person can work out of. Yeah, and again, hours and location are going to be within reason based on what the job is. Obviously, my plumber has to come to my office to fix my sink. We can't do that remote, right? Okay, so again, if we're on this list and if we we pass all of these, then the exemption applies and we're using Barrello instead of AB5. So that's the professional services exemption. The next big one, and this is the one that comes up by far the most, is the business to business exemption. So basically, the government didn't want to mess with straight up true relationships between two businesses working together. But again, there's like way more ambiguity in here than we want there to be. So that's what this is supposed to be addressing. So number one, they want to make sure basically that these are actually two businesses and not just pretending to be two businesses in order to get around employment laws. So number one, does the worker have their own business entity? So business entity, this has caused a lot of confusion. You don't have to have an LLC or a corporation to have a business entity that qualifies under this rule. It can be a sole proprietorship. It doesn't have to be an LLC, but having an LLC might look more legit, but it might not. It's it's under the circumstances. So there just has to be some sort of entity other than the hiring business. Again, free from control and direction. That's what we've been talking about this entire time. The third one is a big one that's hard to overcome. So the worker is supposed to be providing services to the hiring business, not the business's customers. So again, I used that example earlier of having a freelance lawyer come on board and do some extra client work for me. So they're a lawyer, so they'd fall under another exemption too. But if we're just talking about this exemption here, that wouldn't qualify here. They're doing work for me acting like the work is being done by my firm and they're doing it for my clients. So this rule is actually a little bit nuanced because the rule now says, when it was updated, that if the contractor's employees are working under the name of the contractor's business and the contractor regularly does work for other businesses too, then it's okay. So in my lawyer example, if I am hiring another law firm, basically, and I'm telling my client this work is being done by this other law firm, and I'm not pretending like the work is coming from my law firm, then I might still be able to skate by here. But you know, if we don't have it like that, then it's not going to probably pass this test. So if I'm a yoga studio and I have a teacher coming in and I'm acting like the teacher is representing my yoga studio, it's probably going to be a no-go. Okay. The next factor is here. There has to be a written contract between the two businesses. So this is, I think, going to be one of the ones that you could hit every other factor here and not have a written contract, and this fails. So it's really important. And likewise, the contractor has to have a business license. So it's very, very common for small businesses not to even know that they're supposed to have a local business license. And this is hard because, you know, what due diligence do you have to do when you're hiring a contractor to make sure they have a business license? That's something that can be addressed in your contract, and a lawyer can help you figure out. But you have to have a written contract, and the law also has details in there about what's supposed to be in that contract, and they have to have a business license, otherwise you automatically fail. Okay. The other ones look familiar. They have to have a separate location. They have to be doing something different from what your company does. And they have to have the ability to have other clients. Basically, they don't have to always have other clients at the same time that they're working for you, but they have to have the ability to. And there's more, but wait. So finally, the contracting business, the contractor, has to advertise their availability to provide similar services to other people. They have to, within reason, based on the job, provide their own tools and set their own hours and location of work. So again, if they have to be on site to do the job, then of course it's okay for them to come on site. But generally, as much as possible, they should be providing their own tools, setting their own hours, and choosing their own location. They have to be able to negotiate their own rates as well. And again, all of these things have to apply. If one of these factors doesn't apply to your situation, this exemption fails, and we're using AB5. So again, that's why I was kind of drilling down the importance of like having a business license, because all of these things can apply except for that one, and suddenly you're using AB5 instead of Barrello, and we don't want to do that if you don't have to. Okay, so that's all the time I'm going to spend on exemptions right now. As you can see, there are a ton of them and they're complicated. So if you feel like one of those might apply to you or one of your workers, don't assume that it does without talking to a lawyer or someone who is an expert in this, because it's not straightforward. Each one of these has its own rules and its own definitions and its own nuances. So please talk to someone before you assume AB5 doesn't apply, okay? I don't want you to use the wrong test and then you get audited or sued and then lose your business. And I don't want you to get in trouble by accident, for sure, okay? So again, follow up with us. We're gonna have more content with more detail on these, but that's the basics. So if you think one of them applies, do some more digging and contact an expert, okay? So those are the exemptions. Now we've got the basics. We know the two laws. We know the generals of the exemptions. Now, what do we do? Okay, we wanna make sure that you're protected. We don't want you to get sued. We don't want you to get audited. We don't want you to get slapped with huge penalties. So step one, do an audit of your contractors or your relationships with clients if you are a contractor, to assess a gut check of your possible risk here. Please, again, don't assume an exemption applies without talking to a lawyer, because even many lawyers are very confused by a lot of these exemptions. So once we kind of do that analysis of which, does an exemption apply, which test are we using, and then what are our recommendations? The main ones, depending on what's going on, is we'll say these people look like they're misclassified. Let's help you convert these workers to employees if they're really an employee and you're comfortable converting them to employment. If it looks like they could be contractors, we're going to look at the tests and the exemptions to make sure they fit the test as much as possible. So there's as little gray area as possible, because the more gray area, the more likely of getting sued or audited. Some people are comfortable in that gray area. They're comfortable taking the risk because they don't want to have to deal with one or the other. I obviously am not usually going to recommend not doing one or the other, but some people are comfortable with that risk, and that's up to them. And some people also know that the law is kind of in flux, and it's possible that there'll be a new exemption for your industry, or it's possible there'll be a lawsuit that changes something, and some people are comfortable doing the wait and see. I'm just going to keep doing what I'm doing and hope it works out okay. So again, can't recommend that necessarily, but plenty of people have chosen to do that. If you do that, I at least just want you to understand what the risk is. So you do it by choice and not by accident, okay? If we are reclassifying someone, there are going to be a lot of steps involved in that to make sure that you're now abiding by the employment laws, and you're adjusting pay and changing job duties as much as needed. Again, make sure that it's actually an employee or actually a contractor. Plenty of people hate this law. And I think it was not drafted with most small businesses or freelancers in mind. If you feel that this law does not do you any favors, I encourage you to contact your state representatives and let them know what you think and why. I think that they were trying to help people, but I think it unduly burdens a lot of small businesses, and it forces a lot of freelancers who want to be freelancers into becoming employees when they don't want to be. And the exemptions as they are now don't really solve that problem, in my opinion, based on the people I talk to on both sides. So if you agree with me, call your representatives. If you think it's great, you can call your representatives too. But they don't know what your experience is unless you tell them. So I encourage you to do that. So how can a lawyer help? We can help with the analysis of whether they're a contractor or an employee under the law. We can help figure out if one of the exemptions applies to you. If we're going to keep them contractors, then we can help draft contractor agreements for you. Or if you think that they need to be treated as employees, we can help you do that too. Some companies are requiring that contractors have to have an LLC or a corporation, even though this law doesn't actually require that. If you need to do that, we can help with that as well. And also just other things that come up. So whether it's my law firm or someone else, this is not a law to be messed with. And I hope that out of all the things you've taken away from today, that has come across. So please contact an expert if you have more questions about this. And because I don't want you to get sued or audited, okay? So this is our contact information. If you want more information, like I said, we've got a newsletter, we've got our social media, we post all of our webinars and our videos and our articles on there, and we try to do a lot of those. So you know when you need us and when you don't. You can also book an appointment with us directly by going to our website without having to pick up the phone, because I don't like picking up the phone either. So you can do it online if you want to. If you know anyone who freelances or who works as a contractor or works with a lot of contractors, please feel free to send them, our content on this video if you're watching the recording, or send them our contact info if you're watching this live, and you can subscribe to our YouTube and all that for more videos. So that is it for today. I hope to speak with all of you in the future, and I wish all of you the best of luck in your business and in your future, and hope to see you at another one of these things soon. Thanks.